All right, part four. Part four of the video series on capitalization and budgeting in an idealistic civil rights practice or an idealistic plaintiff side practice. This will be the third time I've made this video. The first time had some audio problems. The second time had some lighting problems. And God willing, this will be the last time. That's how we learn, by failing. I talked in the prior video about the scenario of what you call a base hit type practice, and I also talked about the notion of a practice where there were some home run results. And any given version of that is kind of like a snapshot of a practice that's already in operation, looking at it as how it performs over the whole entire year. The capital trough problem, which is what I want to talk about here, is not about that scenario of the already in operation practice, but rather about the scenario of the practice that's getting started and the capital challenges that the practice faces as it gets started. And a law practice is not that different than any other business in that regard. All businesses require an injection of capital to get going, from a lemonade stand to a food truck to a contracting company. It doesn't matter. You got to buy the supplies, you've got to have the equipment, you need the people, or at least some way to support yourself if you're doing it on your own. Law is the same. And in fact, in some ways, law is comparatively capital light. To start, let's say, a cement truck company costs many millions of dollars, probably tens of millions of dollars. Whereas you can run a law practice from a laptop at your kitchen table. If you have the degree and you have the ability to do the cases, that is. So there is this sort of intellectual capital piece of it that has to be supplied by the attorney. But the capital that has to get dumped in is not that extreme. What is different about a law practice, or at least compared to some types of businesses that sell a physical product, is that there is a real delay from the time the business starts going and starts to incur costs to the time when there's any potential payout. All right. And that delay can be on the order of years. By the way, did you see I have my California Western Innocence and Justice Center mug? I'm very proud of this mug. It was given to me by that clinic. And I need more swag. I don't get enough little doodads in my life from the forces of good in the universe. There's so many pieces of swag from the forces of evil. the evil entities hand out the swag like candy, but it's the rare mug that's actually satisfying. Anyway, where was I? The point is that you've got to invest the capital to get going, and there can be many years before the payout occurs. How do you make assumptions about how the payout will happen? The method I propose in the article, and I should have said this at the start, there's an article linked in the description that is the basis for this entire video series. Please go check that out. It has more detail about all this stuff, and it has the actual numbers that I'm assuming or projecting for all this stuff. In the article, I talk about a matrix of 5 cases. And these are just any 5 cases in the portfolio of cases that this firm handles. And the assumption that I posit for that group of 5 cases is that one of them will fail, that being a 20% failure rate, which is hopefully higher than you would actually encounter in real life. But there needs to be some allowance made for the fact that cases can fail. And then I posit that of the other 4 cases, one would resolve in the first year of litigation, one would resolve in the second year of litigation, and 2 would resolve in the third year of litigation. Whether that resolution is through settlement or trial, I guess would depend, although I think the valuation I have assigned to these things in the matrix is based on a settlement scenario, because there's not really any large fee associated with any of them. They're all just sort of valued at 1/3 of a moderate case value resolution. And then the firm is also going to recover costs that have been expended up to the point when the case settles, which will be a certain amount in year one, a little bit more in year two, and a little bit more in year three. And so if you take that assumption to be correct, and again, it's all kind of arbitrary. You could come up with much higher values of the cases. You could assume different failure rates and so forth, whatever. Point is, you got to make some assumptions. And you can plug that matrix into your assumptions about what the costs are going to be for running the practice. And there again, it's necessary to sort of pull some numbers out of the air. But you know that there are going to be certain things that are going to be inherent in any plaintiff side law practice. One of those things is some sort of salary for the person who's doing the work. And it might be very small. I posit in this idealistic scenario a salary of only $30,000 a year, that's not realistic. You can't live on $30,000 a year in most places. But maybe there's other sources of income coming in, or whatever, or other types of work that are going to offset this extremely crappy salary. The point is, you have to make some assumptions. So I'm saying 30,000. You have to make some assumptions about what the cost is of litigating the cases. Each case has its litigation costs associated with filing fees, serving subpoenas and depositions and so forth, court reporters. And then there's just sort of the overhead costs of the firm. And I benchmarked those very, very conservatively at 20, and I mean conservatively like low at, I think, $20,000 a year. And those refer to things like your Lexus account or your Westlaw account, your computer, maybe some kind of office space or a mailbox space, mileage on your car, all the stuff that has to go into making the practice run. And obviously the cost can be substantially higher. And one of the things that's not accounted for in that model I sketched out, which is typically quite a large cost in plaintiff side personal injury practice, is the cost of case acquisition. It's hard to know exactly how you might acquire your cases, but in the PI world, needless to say, that's through advertising a lot of the times. That's why these folks have the billboards and the bus advertisements and so forth. Because advertising is almost, I think, the bigger part of running such a practice. The actual processing the cases is almost an afterthought, but it's getting the clients in the door and converting them into clients in the first place. That is the real art of PI practice, as far as I can see. But when it comes to civil rights practice, especially on the smaller end, it might not be realistic to compete head-to-head with bigger, more established firms. And referrals are another way. If you have some relatively good relationships with other attorneys in your area, referrals can be a way to get cases. Those two have a cost, at least hypothetically, they may have a referral fee cost associated with them. So you have to figure out what that cost is and factor it into your model. And as I say, in the model I have, I haven't included that because it varies so widely. It's hard to know exactly how it might be in your situation. So anyway, those are the sort of the big categories of costs: the some sort of salary, some sort of litigation costs assigned to each case in the portfolio, and the just sort of general overhead costs of running the firm. And I haven't even talked about malpractice insurance, disability insurance, other kinds of insurance that are probably wise to carry, but those need to be in there too. So if you apply the matrix of 5 cases to the costs that are going to come in, you start to come up with the way the costs are going to hit in year 1, year 2, and year 3, and how the expenses will correspond. Not the expenses, but rather the income will correspond to that. And what you will see is that, as Pratik Shah has discussed in the From Solo to Scale podcast, there's a real trough in year 1 and year 2. Because the expenses go out, the income doesn't come in very much in year 1 and year 2, because you're working these cases, you're trying to push them towards conclusion, but meanwhile you have all the costs, or at least a significant number of costs, and the costs are ramping up as time goes on. And so it's not until perhaps year 3 that the numbers start to look more favorable. And even in year 3, at least in the model that I have sketched out, the numbers are not that great. The firm is making 6 figures, but it's not high 6 figures, it's low 6 figures. And the challenge, I think, is that return doesn't necessarily keep pace with many alternatives in the legal marketplace. And so one either has to be at peace with that reality or pursue other strategies for moving beyond that relatively limited economic reality. And there's different ways one might do that. That's sort of beyond the scope of what I'm trying to say. The point is just that it's a challenge to get the practice going, and once the practice gets going, it's not necessarily making oodles and oodles of money. And I think that's interesting because it may seem from individual clients' perspective that the lawyer's making a killing on the margins of these cases. If it's 33% or some lawyers charge 40% in Southern California, the client may feel like, well, that's quite a big chunk of the case. All you did was file some paperwork and maybe do a deposition and look how much you got paid. The point is that to make the practice operate takes quite a number of these cases, and they have to be funded over time, and the payout over time doesn't look quite as thrilling as the payout in any individual case. So that's essentially what I wanted to talk about. The one other thing in this whole universe of considerations that I wanted to emphasize is the way that the Prison Litigation Reform Act really acts to constrain individuals' ability to get qualified counsel in prison cases, because it eliminates this home run possibility, because the PLRA caps attorney fees at 150% of the damage award in a prison case, as long as the PLRA applies to the case. And so if the case has modest value in terms of the damages, it's not going to be much more than that to the lawyer. And so that's going to weed out a lot of cases as viable cases for attorneys who are trying to think about, well, how is this all economically viable? Professor Schlanger, who I mentioned in the article, quotes, I believe, Michael Bean, who works on prison issues, is saying that they don't take prison cases in general unless they can come up with a non-PLRA theory of recovery, and that's specifically because it's so disadvantageous to have the PLRA attorney fee caps apply to a case, and it really constrains you in terms of what you're able to do. But on the other hand, all of this stuff that I've been talking about, all these pragmatic considerations, are just that. They're pragmatic considerations. And I do think that for folks who do civil rights or other idealistic types of plaintiff side practices, the pragmatics are one thing, but the meaning of the work is another. I pursue this work personally, not so much because I think it's a great way to get rich. And in fact, if anything, what the exercise of going through all this illustrates is it's quite a difficult road to hoe. A difficult row to hoe, whatever. You know what I mean? It's challenging, but it's at the same time, I find it meaningful, and that is a real value to me, because I cannot work day in and day out on stuff that I don't think is interesting and significant. I just can't do it. I can't bring myself to do it unless I'm starving or something like that. So it's been helpful to me to work on these cases because I find them fascinating and meaningful. And the fact that it's sometimes possible to do well financially is merely icing on the cake. But I would like it to be something that we could talk about more as a community to figure out how can this be done in a way that's viable for more people. All right, that's all I got to say. Thanks for watching, and I hope it's helpful to you. Please do check out the article on the website. Peace.